Hi everybody, my name is Joe Murphy. I'm a lawyer with Allegheny Immigration Group here in Pittsburgh. I practice primarily humanitarian and family-based immigration law. Our phone number is 412-586-4131, and please like and share this broadcast if you find it valuable. In my last live, I discussed immigration based on marriage. There were some questions afterwards, and I figured I'd do another live and talk about that some more. In the hypothetical I used last time, the parties had met in a foreign country, got engaged, and the American was back in the United States and wanted to have their foreign fiancé come to the United States for the purpose of marrying. That was the plan they made when they got engaged. Much more common is when an American citizen marries a foreigner in the United States, perhaps someone who's here visiting on a student visa or is here as a tourist. They meet, they fall in love, and they get married here in the United States. In a situation like that, you don't have to file for a fiancé visa because your alien spouse is already your spouse and is already in the country. So you would start, obviously, by getting married, and then there would be some filings that had to be done. Initially, the American citizen spouse would file a petition for alien relative, and in that petition they would identify themselves, identify the basis of filing, in this case for a spouse, because that form can be used for other people, but ultimately in the case I'm outlining it's for a spouse. They'd have to attach some evidence. If this is immigration being based on marriage to a citizen, you'd want to attach proof that the person filing it, the American citizen, is in fact a citizen. And in that case, you would attach either a birth certificate, hey Sean, showing that the citizen filer was born in the United States, a passport. In certain cases, there'd be other types of ways of proving American citizenship, but those are the main ways. The American citizen would also have to include proof that they are in fact married to the foreigner. Normally that is a marriage certificate. Another big category which sometimes causes problems is proof of the financial ability to support the alien spouse. If you're importing, so to speak, someone to the United States to become a citizen as your spouse, you have to prove the financial ability to support that spouse. And that's done by attaching tax returns, and there's a calculation that's done on a form called I-864P to demonstrate that the American citizen petitioning for a green card for his non-citizen spouse has the financial ability to support. Those are the main categories of things that have to be attached to that petition for alien relative. There's also another category which I discussed in my last live about immigration through marriage, and that's evidence of bona fides. And that's, I think it's Latin. It's two-word, B-O-N-A-F-I-D-E. It means that the marriage is real. And that would be evidence that these people who are claiming to be married are in fact, hello Sammy, are in fact married and are in fact acting as married people. You want to have evidence there that this is not the stereotypical fraudulent green card marriage. And that would be evidence of commingling, a joint checking account, a lease or property ownership together. The one example I gave is, so to speak, the ultimate evidence of commingling would be a kid you had together. Other things, it's not designed so that you have to be wealthy people. You don't have to have put your spouse's name on the deed to the condo in Aspen. So in cases where the people maybe don't have property together or significant bank accounts, you can use things like, I've used joint magazine subscriptions, I've used joint leases for furniture or stereo equipment in the house. Those things all indicate commingling, and they all indicate in the direction of acting like married people. At the same time, the citizen files that petition for alien relative and attaches all that evidence that they are married, that they are divorced if they were ever married before from the prior spouses, that they have the financial ability to sustain this person, and that they are in fact, hey Cody, a citizen. The alien also files at the same time what's called an I-485 application to adjust status. He's in the country, or she's in the country, on one status, and that might be tourist or student, as I said earlier, and now wants to change their status to conditional permanent residence. So the alien would then attach a whole bunch of things, but this is really, who is this person? They would have to give evidence of who they are. They have to attach the photograph, picture of their passport, even some information about family members, who their parents are. And there's significant filing fees with these. I was just looking at it today. The fee for petition for alien relative is, I think, $535 at the present. And, hey, Dinesh, and the petition to adjust status is around $1,100. So, you know, there's some significant fees here. And that's not fees the lawyers get. Those are fees that go directly to USCIS. There's some other things you'd file besides just the base petition, the petition for alien relative, the petition to adjust, and the proof of financial ability. Presumably, if you're applying for the immigration of your spouse, you'd want them to be able to work, so you'd apply for work authorization. Depending upon where they came from in the world, you might need some travel documents applied for and the like. Alien relative. Sammy is asking, what does alien relative mean? That means a non-American that is related to an American. So if I were to marry someone who was not a citizen, I mean, I'm already married, but if you were to marry, I know you're single, if you were to marry someone who's not an American citizen, because they're not a citizen, they're an alien, and because you're now married, they're now your relative. They'd be your spouse. So that's what I mean by alien relative. And that's a good question. Sometimes I use immigration jargon, and it's great to have the questions to help me talk in a more easy to understand language for non-practitioners. So after you file all that stuff, usually the first thing that comes back is a receipt for the filing of these documents. That's not an acceptance notice. That's just the government saying, we've got your stuff. Shortly after, and ideally, you'd get an acceptance notice. And the difference is, a receipt is just the date they got it. Acceptance would be they've looked at it and it passed preliminary muster. In some cases, people, particularly people who are doing this by themselves, don't attach enough evidence of bona fides, or they attach, in some cases, too much, or even stuff that really makes no sense. So you'll get back what's called an RFE. That would be a request for more evidence, and it's usually on the bona fides issue. They'll be asking, do you have anything else? And you get a time. It's something like 87 days, and they'll say, please provide more evidence that this is a bona fide marriage within 87 days. That happens, and it's kind of an unpredictable process, that RFE process. It's really subject to the discretion of the individual officer that evaluates the applications. We've tried to predict it, but because different people have different moods and criteria, and even on different days, it's not easy to predict. Obviously, we're better than most because we do a lot of it. Ultimately, it'll either be accepted or you'll comply with the RFE, and then you'll get an acceptance notice, and then we're off to the races. You may be called in, the couple may be called in for interviews to investigate, again, to prevent marriage fraud. And in those interviews, they would ask things that married people would know. What's his mother's name? Where was she born? Where did you two meet? They can even separate the couple and ask them questions separately, particularly where marriage fraud is suspected. And I talked in my last live on this subject about the fact that the service is very, very good at detecting this fraud. All right, there's a question again from Sammy. Is an alien relative automatically qualified to be a U.S. citizen? The answer to that is no. By marriage to an American citizen, you don't become a citizen, not right away. You become a conditional permanent resident for 2 years, and that condition is that the marriage be bona fide and you stay in the marriage for 2 years. After the 2 years are up, the alien can apply to have the conditions removed and become a regular permanent resident. And again, it's very important if anybody's watching this live and is going through the process, you want to have your application to remove conditions into the service at least 90 days before your conditional status expires. If you don't have that application in, well, let's do it this way. If you wait till 2 years and 1 day to file to remove the conditions, it'll be impossible to remove conditions because the conditional permanent residence will have expired and the alien will be out of status. And there are mechanisms to late file or just restart the process, but it becomes a pain, and that alien starts being exposed to jeopardy in that time that they're out of status. So you do want to get that petition to remove conditions in 90 days early. If you send it in before 90 days, it'll be rejected, and any time you spend after 90 days, you're, so to speak, playing with fire. But after the conditional permanent residence, the alien removes the conditions and becomes just a regular permanent resident. They have to do that for another 3 years, and after those 3 years, then they can apply for naturalization, and that's how they become a citizen. And that's assuming there are no other problems presenting a bar to them adjusting to any of these underlying statuses. And I gave the example of one where the alien doesn't apply in a timely fashion to have the conditions on their conditional permanent residence lifted. Another example would be where the alien, before the marriage, has been in the country unlawfully for a period of time. When you're in the United States unlawfully, and this could be people that walked across the border, it could be people that came in a lawful status and that status expired and they stayed beyond it. At either when the status expires or the moment that you're in the country illegally, you start accruing, that is you, the alien, unlawfully in the country, what's called unlawful presence, and that's counted in days. Up to 180 days, there aren't terribly significant consequences. You may not be able to get a new visa to come back in the country if you go home, but after 180 days, you're barred from the United States for a period of 3 years. After a year of unlawful presence, you're barred for 10 years. So this can become a serious problem if the people get married and the alien has significant unlawful presence. Sure, Sammy is asking me to clarify what a conditional permanent resident means. Conditional permanent resident is a status that is given to someone who applies for permanent residence because they're married to an American citizen. There's a concern about marriage fraud, so they don't give them just regular old permanent residence. They give them a permanent residence that's conditional, and the condition is that they are and stay married to the American citizen and that the marriage be a real marriage. It can't be, as so to speak, and as we discussed before, a fraudulent marriage. All right, back to where I was at. We're talking about having married someone who's been in the country for a long time illegally, and someone who'd accrued unlawful presence time. And again, up to 180 days, there's no ban from the United States. There may be other immigration consequences. The government may refuse to renew the visa. But after 180 days of unlawful presence, the alien's subject to a 3-year ban from the United States. And after a year of unlawful presence, the alien's subject to a 10-year ban. So this is pretty serious stuff. If you've married, or if you're planning on marrying, someone who has a lot of unlawful presence, you need to apply as part of this process for a waiver, and that is basically asking the government to waive those punishments. And that in that waiver, you have to demonstrate an extreme hardship to the American citizen, spouse, and/or family. And by extreme hardship, they mean more than just being separated from your spouse. There has to be some serious hardship that will be suffered by Americans if you are barred from the United States. Because what they do, if the waiver isn't granted, they can't say you're not married, but they can say they're not allowing you to adjust, and you may have to wait the 3 or 10 years out of the United States before a green card's issued. So where you have that, you definitely want to talk with competent counsel about getting a waiver of unlawful presence executed. These become a lot easier to get when perhaps the spouse, that the citizen spouse is has some sort of disability and really needs the care of their foreign spouse, where there's a child, and because refusing to allow the waiver would result in depriving the American citizen child of one of his parents. Things of that nature, and competent counsel can help you develop the grounds for a waiver. Hello, Barbara. Hello, Dennis. Hello, Chris. Hey, how you been? So that to Sammy's original question, it's not automatic citizenship, and it may not even be automatic permanent residence where the alien has unlawful presence. Other things that can really mix it up is where the alien relative, the alien spouse, has committed significant or serious crimes in the United States, or has been involved in human trafficking and a number of other kind of outrageous offenses. But those can be bars. They can prevent the thing from going altogether. So can fraud. Any act of lying to the government on a immigration application is even the worst ban. It's a lifetime ban from the United States. And you can also get a waiver for that, but that's a very, very difficult waiver to get. So we kind of got a little bit along down the road, but you got a feeling for what's happening here. If the green card through marriage is a conditional green card, and that means that you have to be in a bona fide marriage, and you have to stay in that bona fide marriage for a period of 2 years, and then you can have the conditions on your permanent residence lifted. And as always, I always remind people, you want to apply at least a minimum of 90 days before your 2-year anniversary, because you want a smooth transition from conditional to unconditional permanent resident. If that goes smoothly, you'll be issued a regular permanent resident card, and if you, I guess, wanted to at that point, you could separate or divorce from the citizen spouse, and because you're no longer required to be in that marriage. Now, most marriages that make it 2 years can last, but anything can happen. Things break down all the time. What if there's abuse or just a breakdown of a bona fide marriage before the 2 years are up? What can an alien in that position do? What if there literally is physical or life-threatening abuse in the marriage? The alien can, in those unfortunate circumstances, file themselves. They can self-petition to have the conditions removed and be given a regular permanent resident card. That's obviously an unfortunate situation, but that can be done. And this is a result of the Violence Against Women Act and how it affected immigration law. Sammy's asking, what would qualify a marriage to being labeled a fraud? Okay, that's a good question. Who gets to say what marriage means what? If the couple were invited in for an interview and one of the parties didn't come at all, that would certainly raise suspicion. Now, that could be anything. It could be a flat tire on the way to the interview. No, divorce, abuse, and physical and verbal threats does not necessarily make the marriage a fraud. That's a separate thing, and I'll get to that in a moment. But a fraudulent marriage is one that's just for the purposes of getting a green card. In many cases, even if the people engaged in a fraudulent marriage go to the interviews, they don't know anything about each other because it's a fraud. They don't have anything together. And a lot of these fraudulent marriages, there's some money changing hands, and the citizen who is engaged, a co-conspirator in the fraud, if you would, with their spouse, doesn't want to spend any of that money they got to engage in this fraud on building a home, because they're not interested in building a home. They're interested in getting that money and selling a fake green card. So that's one of the ways they would catch it. The people don't know each other. They don't have any of the things that would normally qualify them as married people, and or one or both of them refuse to attend marriage interviews. So that's the fraud, and that's just people pretending to be married. Now, they're legally married. I mean, once they go and swear to love and all that stuff in front of a judge or a religious figure, they are legally married. But that's not enough, because the service wants it to be a bona fide marriage, a real live marriage of an American to a foreigner, in the sense that we understand that concept. And it may be an outdated or traditional concept, but that's what we have. You know, the idea that these people intend on living together, making a home together, sharing their futures and dreams, perhaps even having children. And they're looking for those sorts of things. And the lack of them certainly would cause suspicion. Now, Sammy also asked about divorce, physical, and verbal threats. That's not necessarily proof of a fraud. What it is proof of is that the two people that are married, it might be dangerous to one or both of them if immigration law were to force them to stay together just to get a green card. So in those circumstances, the alien spouse, even if they're at fault, so to speak, in bringing about the abuse, can self-petition to have those conditions removed, and normally attaching like a PFA, or that's a protection from abuse order, or a report of a psychiatrist or a psychologist or other mental health worker that they've been treating for abuse. There'd have to be some proof other than just the alien's allegation, but those can be granted. And again, that is to prevent what could be a potentially dangerous situation where people who are at each other's throats, if you would, are forced to stay in the marriage to get a green card. So, okay, now scenario. What if both actors don't know each other? Then logically they are not married. Well, legally they can be. People that don't really know each other can go get a license and go through the motions, get a marriage certificate. That is proof that they went through a marriage ceremony. It's not proof that they are in what the service calls a bona fide marriage. And that's just the rules. This marriage certificate is not enough. It's just not enough to prove it for immigration purposes. So and that's what you have to do. There'll be interviews. There'll be proof that you submit. If you do the 2 years, and then again 90 days before the 2 years are up, you apply to remove conditions. That would normally be granted. Then the alien spouse is in an unconditional permanent resident status. They no longer have to stay in the marriage, although they might. They don't have to get out of it. 3 years after the conditions are removed, the alien spouse, now permanent resident of the United States, who may or may not have stayed in the marriage, can apply to be naturalized to become a citizen of the United States. Hey Troy, how you doing? My name is Joe Murphy. I'm a lawyer with Ali Immigration Group here in Pittsburgh. My practice is primarily in humanitarian and family-based immigration. Our phone number is 412-586-4131. If you like this video, I ask that you hit the like button or share it if you find it valuable. So we were talking about immigration through marriage, and I think Sammy had some very good questions. Well, thanks for stopping in. About marriage, immigration, when a marriage is fraudulent. And you have those problems, and it's critically important that this be real, even from the perspective of us as a law firm preparing and submitting these applications. We want to have a little bit of a look at it ourselves. We certainly don't want to be known as a firm that files fraudulent applications either willingly or either wittingly or unwittingly. So we look at it too. I mean, we're not in adverse interest to the client, but there has been, unfortunately, situations where people came in with an obviously fraudulent marriage going, and I had to withdraw from representation in those cases, unfortunately. For the clients, for me, it's good that I figured it out. So that was immigration through marriage, and that's not a fiancé visa, which was my last talk. That's people where the alien spouse is already in the country, and then they get married here. And as I said, in that situation, there's no need to apply for a fiancé visa for two reasons. One is that the alien is not a fiancé. It's a spouse. They're already married. And the other reason is they don't need a visa to get in the country because they're here. And this is the typical situation where an American meets someone here on a student visa or a tourist visa. They fall in love and they get married. So immigration through marriage is a neat issue, and there's a lot of things that circle around it, a lot of curious issues. We're very happy. We handle a lot of this work. It's very nice and it's romantic. It's wonderful to see young people One thing, because the people who tend to be engaging in marriage, getting engaged in doing marriages, if you want to use that, are younger, sometimes they have a hard time meeting the financial support capability. There is a published guidelines, I-864P is the guideline form, you could look it up yourself. But the citizen who is sponsoring his alien relative, alien spouse for a green card has to demonstrate a financial ability to support this person. Where the citizen doesn't have show the income on tax returns to meet the minimum requirements, they can get co-sponsors. They could get a relative, they could get a friend to add to that filing their income. The problem is when you add a friend to the income, you also add another person who's dependent upon that income stream. So the more people you add, the more that you have to show. So if you used a friend who had 4 kids and a wife, that would add 6 people to the 2 that are getting married. So now you'd have to have in combination enough income to support 8 people. And so that can be a trap for the unwary there too. On the flip side of that, a very nice thing to see on an application where the citizen spouse does not have enough or does not show enough income on their tax return to meet the guideline amount is to have the parents of the citizen spouse co-sponsor the alien, because that goes not only to satisfy the support obligation, but it tends to indicate bona fide marriage. Clearly, if son or daughter got into a green card marriage, parents wouldn't be co-sponsoring it. It's an indication that the parents are aware of this marriage, that in many ways they approve of it or at least are willing to contribute to it. So that's the support guidelines and how to get over that if you don't have enough income on your own. Let's see, what other issues were important? I mean, I really think the biggest thing, and I've seen some cases on this just recently. Okay, so Sammy's asking about the interviews, I believe. If they respond incorrectly to questions about each other and questions about their marriage, aren't they... Well, it got cut up into 2 bubbles, but I get where you're going. Maybe yes, maybe no. The service, USCIS, is very good at weeding out fraud. I've been to interviews where the people were so nervous they got everything wrong, and it was still approved because it was obvious they were in love and a couple to the satisfaction of the officer conducting the interview. I think they're looking more for someone who looks guilty when they don't have the right answer as opposed to someone who has the right answer. It's an evaluation of these parties for character, for untruthfulness, rather than their ability to remember someone's phone number at work or someone's mother-in-law's name. So yeah, that's a good point, Sammy, because that's a very, it's nerve-wracking going into these interviews, especially with so much on the line. People do commonly shut down, and people do commonly build that up. And I think that what they're looking for isn't people that know everything or have everything at their fingertips, but they're looking for liars. And then there were obvious cases where these people, I mean, I've had, and I'll talk to you here just for a moment about one I had, and it's kind of funny. This was an immigration by marriage case, and it had to be, I think, 15 years. Part of the process is that the alien spouse has to have a medical examination to make sure that they're not carrying horrible diseases, infectious diseases, and so on. And as is the case, we sent the woman to a medical office near my office in downtown Pittsburgh to have her medical exam. And I showed the lady where it was, and she left my office and went across the street and down the block to this office with the form that needs to be filled out by the immigration surgeon. And about 15 minutes later, she called me from the waiting room of the immigration surgeon's office and said, "Joe, I'm having a problem filling out these forms." And I said, "Okay, what can I help you with?" She asked me, "What is the name of the guy I married?" There's an obvious immigration fraud, and I couldn't continue on with that case. It's crazy. The woman didn't even know the name of the American she married. So that's a good example of an obvious and kind of screaming immigration fraud that I had to drop out of. And you don't like to do it, but when you do, it's always the best decision if you have suspicions yourself as a lawyer. And that's not to say I look at every marriage case or any marriage case that comes through my office with a suspicious eye. But when these glaring problems come up, I'm not allowed to pursue the case. Yeah, it is pretty funny, Sammy, that the woman didn't even know the name of the guy she married. Well, and that's a good point. I think I'm going to stop this live if you guys are satisfied with the information. Obviously, my name's Joe Murphy. I'm a lawyer with Allegheny Immigration Group here in Pittsburgh. Our telephone number is 412-586-4131. If you like the video and find it valuable, please like and share. Hey, Matt, how you been? That's all I have for today. Again, don't hesitate to send me a text or call. I'm available, and I love to talk about immigration. It's something I really enjoy doing, so I hope to hear from you all. Thank you, and thanks for tuning in. I'll be back on probably, I may be on over the weekend, but I'll definitely be on next Thursday at 6 if you want to watch. All right, bye-bye, everybody.